This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning, and thank you for participating with us in this Zoom oral argument. Want to tell you we appreciate you accommodating us. This is probably not the best way to do things, but it's the best way we can do things now in light of the pandemic we're involved in. Both of you are experienced practitioners, so I don't want to bore you with going through the ground rules, but those ground rules will apply. Each side will get 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, and I'm sure you've already reserved that with Mr. Hibner, then you will get that rebuttal time. One thing I do want to do is to introduce the panel before we start. Your panel for this morning will be Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. And we want to thank Mr. Hibner and the AOC staff, as well as Mr. Hibner's staff, for working so hard to put this together. Mr. Hibner, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the first case then.
John L. Smith Jr. versus Giovanni Gonzalez et al.
All right, we will hear from the appellant.
Good morning. May it please the court. Chad Rickman on behalf of the appellant, John L. Smith Jr. This case involves a December 2, 2017 automobile crash occurring in Memphis, Tennessee. On November 30, 2018, Mr. Smith filed his complaint for negligence against the other driver, Giovanni Gonzalez, and the appellant, James River Insurance Company, was served the complaint as an unnamed defendant as Mr. Smith's uninsured motorist carrier. Now, at the time this was filed, I had been with the law firm for less than a week and had not yet had my electronic account set up with Shelby County courts, which, as I know the court knows, the Shelby County Circuit Court has an electronic filing system where pleadings can only be filed by a licensed attorney registered with the court. Because I did not have that yet, the complaint was filed by an associated attorney, Mr. Severes, out of what at the time was the firm's Nashville office and affiliated. Mr. Severes was an attorney who had filed on behalf of the firm's clients on several occasions prior to this with the trial court. And again, that was filed November 30, 2018. James River answered on February 14, 2019, and filed a motion to dismiss under Tennessee Rule of Civil Procedure 12.026 for failure to state a claim upon which relief can be granted based upon an asserted failure to comply with Tennessee Rule of Civil Procedure 11.01. In that, Mr. Severes, when filing, omitted his name and his bar number from the complaint. It did include mine, but not his own. An answer was filed to this motion on July 10, 2019 that included a sworn affidavit from Mr. Severes establishing that he had in fact signed Mr. Smith's complaint. And of course, this is also borne out by the fact that Shelby County's ECF system sets out who files every pleading, and it's clear from that public record that Mr. Severes had in fact filed the complaint as a licensed attorney representing Mr. Smith in this case. This matter was heard on July 9th.
Mr. Rickman,
Yes,
you just mentioned some things about what we should be able to take judicial notice of, I assume. Is that in the record, or is that just something that you think is common knowledge?
Well, Your Honor, it's not. It's in the transcript of the proceeding. It was pointed out to the trial court that in fact Mr. Severes was the filing attorney in this case, and of course, as the court has seen a note to our response to the motion to exclude the appendix in this case, it is a matter of public record which the court, including the appellate court, can take notice of, and it is a fact. I mean, Mr. Severes filed the complaint in this case.
Okay.
Let me ask you a question. Are you saying that, in other words, he could not have filed it unless he was a licensed attorney because of the way the electronic system is set up? Is that?
That's exactly correct, Your Honor. He could not have filed it unless he was a licensed attorney registered with the trial court.
Is that? I know you filed an affidavit from him in response to the motion to dismiss. Is that information contained in that affidavit?
No, Your Honor. That's just a matter of public record. Any member of the public with access to the internet can access that through the court's website and determine who the filing attorney in the case is. I do not believe that was addressed specifically in the affidavit.
All right, thank you.
Thank you, Your Honor.
Let me make sure I understand this, Mr. Rickman. So there is a electronic signature with Mr. Severe's name on it in connection with this complaint?
There is not, Your Honor. There is
not
not
an electronic signature.
There's not. Just the fact that he was the filing attorney is established by the court's records. And then his affidavit established that he signed the original complaint on my behalf, although he admitted including his information in that.
But he did not sign his individual name. He signed your name.
Yes, Your Honor.
And is there any explanation as to why all the information was not included in the signature line?
That was not included in the affidavit, Your Honor, other than the fact that he did sign it and he provided that information in the affidavit that was omitted from the original complaint when it was filed.
So as far as any explanation, the record is devoid of that. Would that be accurate?
Yes, Your Honor.
Okay.
The motion was heard on July 19, 2019, at which time the trial court found that the complaint was void upon filing, granted the appellant's motion to dismiss, and denied Mr. Smith's motion to amend his complaint to add the information that was subsequently provided by Mr. Severe's affidavit, but omitted from the original complaint. And Your Honor, the cases that were relied upon by James River in supporting its motion, and the cases that the trial court relied upon in granting the motion, are all clearly distinguishable from Mr. Smith's case. Appellant cited the Old Hickory Engineering case, which is a 1996 Tennessee Supreme Court case, as well as the Dual Shirt Manufacturing Corporation case, which is an April 7, 1999 case from the Court of Appeals. In each of these cases, Your Honor, and actually in the third case that was cited, the Willett versus Holtz, which is a Court of Appeals case from October 6, 2010, but the Rule 11 defect in each of these cases turns on the same fact, and that fact is who filed the complaint. In none of these cases was the original complaint filed by a licensed Tennessee attorney. In Old Hickory Engineering and Dual Shirt, both of those cases, a non-attorney corporate officer filed the complaint on behalf of a corporation, which of course is improper. And in the third case, the Willett case, a spouse filed the complaint for the other spouse, which was a pro se claimant in the case. So that's clearly distinguishable from this case, because in none of these cases did an attorney file the original complaint, and that was, and the court, the appellant has argued, and the court found that Mr. Smith did not act promptly to correct the defect, but the defect in each of these cases was the fact that there was no attorney involved to start with, and they tried to get an attorney involved later. And although the trial court found that there was an unreasonable delay in responding, by its own ruling, the complaint was void upon filing. So by the time this issue was raised, it would have been too late, if in fact it's appropriate to dismiss the complaint on these facts, Your Honors.
You didn't make any attempt to correct this according to my calculation, for over 5 months.
Well, Your Honor, and there were reasons for the delay, and I stated those during the argument is unfortunately about the time this happened. I had some issues in my personal life. My father's health took a downturn over several months and up and down with a couple of hospitalizations and ultimately his passing. And I was out of the office for several weeks at a time. But the fact of the matter is, Your Honor, is by the time it was raised, according to what the court found, it would have been too late anyway. It had been too late on the day it was raised because the court found that the original filing of the complaint was void upon filing, and that therefore the statute of limitations is run, and therefore it was futile to consider our motion to amend.
Well, did he find that it was void because it was not because the time had run, or I think according to what he said, the court finds this is not a case where amendment of the complaint is proper, since counsel failed to correct the Rule 11.01 deficiency in a timely manner as required. So do we know that he would have declared it void if it had been corrected in a timely manner? He appears to rely on that timely manner language.
Well, Your Honor, what the court did say at page 23 of the hearing is that the complaint is void and frankly of no significance since it was not signed by an attorney. So the court found it was void upon filing. So there would have been no time to correct it by the time this was raised. And that's why the court went on to find that the amendment would be futile in the sense that the statute of limitation is now run upon the claim as it stands. Of course, the statute would have run by the date that this defense was raised. And again, Your Honor, all of these cases, each and every case where the court found that a claimant did not act promptly was a case when there was no attorney involved. Mr. Severes filed the complaint. Mr. Severes signed the complaint. We filed an affidavit providing the information that was omitted from the complaint and sought leave to amend it. And that leave should have been granted in the interest of justice.
All right, you've used your time, Mr. Rickman. Judge Golden, did he answer your question, or do you have?
I don't have any follow-up. Thank you.
Okay. All right. All right. We will hear from the appellee, and then you will have your rebuttal time, sir.
Thank you, Your Honor.
Yes, sir.
Your Honors, may it please the court, my name is Colleen Schutz of the Shelby County Bar, and I'm here today on behalf of the appellee James River Insurance Company. And as an initial matter, I wanted to address a couple of points that Mr. Rickman had raised in his argument. First off, Mr. Rickman referred to a matter that's outside the technical record about Mr. Severes and what was filed. And this was the subject of a motion to strike. And that motion to strike was granted by the appellate court. And therefore, that is not something that this court should take judicial notice of. That issue has already been decided by this court respectfully. And so I would ask that you please disregard any reference that was made as far as that was concerned. Additionally, with regard to what was
ignore, I'm not sure I'm clear on what you want us to ignore.
Yes, Your Honor. Mr. Rickman had indicated that Mr. Severes was the one who had done the electronic filing of the complaint, and in his reference to that, he was referring to an appendix that he had attached to his motion indicating who did or did not file the complaint. And as far as who actually did the electronic filing, Your Honor, that matter was not presented before the trial court, and that should not be considered under judicial notice by this court, Your Honor.
Oh, that was never even brought before the trial court?
No, Your Honor, that the fact that Mr. who did the filing of the electronic complaint, that issue was not raised before the court. And that is also not the subject of Mr. Severe's affidavit. His affidavit, which is contained at technical record 28, merely says, it identifies Mr. Severes, and it has his name, his bar number, his contact information, and it just indicates that he signed the complaint It doesn't actually indicate that he filed it or that he electronically filed or that he was involved with the filing of it. It says it was filed. It does not indicate that he filed it or that he was the one who did that. Your
All
Honor, that's why we're respectfully asking that you not take judicial notice of that.
Well, that leads me to a question, counsel. What is it your understanding as to why the trial court dismissed this complaint?
My understanding, Your Honor, is that the trial court found that the complaint was void, that the notation.
Okay, let me stop you there. Void because of why?
It was void because the notation on the complaint was non-compliant with Rule 11.01. It didn't meet the.
Okay, and let's go a little further. What was missing?
What was missing is Rule 11.01 requires that counsel of record sign a complaint and include their bar number, their Board of Professional Responsibility number, or a party file the complaint and sign the complaint. And in this case, if Mr. Sievers was the one who filed the complaint, or if he was the one who signed the complaint, he did not include his bar number, and he also never appeared as counsel of record. So regardless of whether.
Okay, let me stop you just a second. The posture that this case was in front of the trial court was complaint had been filed, you file a motion to dismiss, and then a response is filed along with this affidavit. Is that accurate?
Your Honor, we did file an answer and motion to dismiss, and within our answer and motion to dismiss that we filed on February 14th of 2019, I'm sorry, I think of, yes, of 2019, Your Honor, we made it clear to plaintiff's counsel that there was a deficiency with their complaint at that time.
Okay.
And
what I'm trying to ascertain, though, is the evidence that was in front of the trial court. You had a complaint, you had your answer and your motion to dismiss, and you had the response of the plaintiff along with the affidavit of Mr. Sievers. Is that pretty much it?
Yes, Your Honor. We also filed a supplemental memorandum of law in May 24th of 2019. But yes, what you referenced, that is what was before the trial court.
Okay, so what the trial judge had was the complaint, had you pointing out in your answer and motion to dismiss what was lacking. Then you've got an affidavit filed by Mr. Sievers saying, I in fact signed that with permission of Mr. Rickman. There is no countervailing evidence in the record at this point in time, is there?
I'm sorry, could you clarify your question, Your Honor? I just want to make sure I'm answering it.
When we consider this motion to dismiss, we have to take Mr. Sievers' affidavit as correct. Do you agree with that?
My understanding is that it's a sworn affidavit. Yes, Your Honor. So
Okay.
You have to take the affidavit as correct.
So what we've got is Mr. Sievers saying, I filed the complaint or I signed the complaint by permission for Mr. Rickman. Would that be accurate?
Your Honor, that would be accurate. However, our position is that.
Now, just stay with me for a minute. I'll let you argue in a minute. I'm just trying to make sure we get the facts out here.
Absolutely.
So the only thing then that is lacking would be what? The bar number?
Your Honor, it would have to be signed in Mr. Sievers' own name, and he would have to appear as counsel of record. There's nothing within.
He says in his affidavit, he says he signed with permission on behalf of Mr. Rickman. Don't we have to take that as true?
Your Honor, you do have to take that as true. However, nothing within the Tennessee rules of civil procedure actually allow for signing a complaint, an initial pleading with permission, and allow for that custom and practice. Mr. Severs could have easily either added himself to the signature block and just signed in his own name, or could have filed a notice of appearance.
So do you have anything in the rules of civil procedure that say you can't sign by permission? I've seen it done many times.
Your Honor, I've only seen local rules and the custom of practice regarding signing with permission. And my understanding is that that pertains more to the signing of orders and not to initial pleadings initiating a lawsuit.
Okay, well, assuming that our analysis of the facts thus far are accurate, the thing missing is the bar number. Is that right?
The bar number is missing, Your Honor. My position is that that is not the only thing that was missing, and that Mr. Severs should have signed in his own name or filed a notice of appearance.
Well, that's not what the trial court said, though, was it?
Your Honor, the trial court found that it was an invalid notation, that it didn't constitute a signature. Did I answer your question, Judge Stafford, or did you have anything further that you wanted to ask?
I think you have thus far. So did the trial court go on and then determine, based upon what Mr. Rickman said were the reasons for his failure to properly amend, that those reasons were invalid or would not allow an amendment?
So the trial court specifically found that, I'm sorry, Your Honor, the trial court specifically found that the complaint was void, and it did consider what Mr. Rickman said. He did bring up his father's health before the court. However, our position is that this was not proper for Mr. Rickman to bring this up before the trial court. There was no affidavit regarding his father's health issue, and this would have been more proper under Rule 60.02 after the court had made a determination, and that it would have been more appropriate for Mr. Rickman to bring this up under Rule 60.02 motion. Additionally, the trial court did consider the timeliness of Mr. Rickman's response. The cases that we cited, Your Honor, all of those cases, while Mr. Rickman is trying to argue that they are distinguishable, yes, admittedly, they all dealt with pro se individuals. However, as we enumerated within our brief, pro se individuals are customarily provided with more deference and leeway by the courts because of their unfamiliarity with the legal system. And in this case, we made it very clear to Mr. Rickman that there was a deficiency with his complaint. We said it in our answer and motion to dismiss on the very first page. And we also made it clear to the trial court and told the trial court that we had notified Mr. Rickman by email as well. And we also indicated within the third defense of our answer and motion to dismiss that there was a problem with the statute of limitations. And Mr. Rickman was made aware of all of this at the beginning on February 14th of 2019.
Let me ask you another question, counsel.
Yes.
Did the trial court utilize the proper procedure here? And my reasoning is this. The trial court treated this as a motion to dismiss under Rule 12, but it also considered an affidavit. Why should this not be considered a motion for summary judgment?
Well, by the standard the motion for summary judgment does, for motions to dismiss, you obviously are just looking at what's within the pleadings, and obviously by it being an affidavit being considered, that could have converted it to a motion for summary judgment. However, we would argue that the facts of this were undisputed, so we could have proceeded under a motion for summary judgment as well, Your Honor.
So the facts are undisputed here. Is that what you're saying now?
The facts contained within the complaint, the fact that the
No,
motor
I'm talking about the affidavit as well.
We are not disputing that Mr. Rickman supplied this affidavit, Your Honor, and that Mr. Sievers made these representations within it. Our position is still that even if these representations were made within the complaint, that still is insufficient to cure the deficiency and that it was not done in a timely manner. The fact that Mr. Rickman waited 146 days to file this response to our motion to dismiss and to seek the relief of a motion to amend at that time. That's our problem, is that Rule 11.01, it requires that once that an unsigned paper be stricken, shall be stricken, which is mandatory.
If we're taking Mr. Rickman's, or if the affidavit of Mr. Sievers is truthful and accurate, then it's not an unsigned paper. It's a legal question as to what the validity of that paper is. Now, and let me go to another question before your time runs, and that's this. Trial court dismissed this for failure to state a claim. It said that the complaint was void. Actually, what the trial court is saying is the statute of limitations ran, isn't it?
The trial court did find that the statute of limitations ran because it constituted a void pleading.
So we're not really dealing with a failure to state a claim, are we?
Well, Your Honor, I know that plaintiff's counsel has argued that we're trying to favor form over substance. However, respectfully, strict compliance with Rule 11 is required, and it's the rule of which attorneys are most keenly aware and that they don't want to violate. And there are moral and ethical obligations inherent with making sure that an attorney signs the complaint. And it also can serve as the basis for holding losing attorneys liable for the costs and expenses of the prevailing party. And we also enumerated within our brief that the signing of a pleading by an attorney of record of the party is an essential condition to the validity of the pleading. And this was a standard that was enumerated in the Tennessee Supreme Court case of Old Hickory Engineering and Machine Company Incorporated versus Henry.
Thank you. You used your time.
Well, let me ask one thing. You aren't arguing that you can't correct a Rule 11 deficiency after the statute has expired, are you?
No, Your Honor, I'm not arguing that it can't be corrected after the statute is expired. The standard here is to correct it promptly. And in this case, Mr. Rickman waited 146 days, and that was not a prompt correction. The cases we cited dealt with 37 days, 45 days, where the court didn't find that was a prompt attempt to cure a deficiency, and those dealt with pro se individuals.
Are you also arguing that that deficiency could have been corrected by Mr. Seaver filing a notice of entry as a lawyer on the case?
Yes, that could have been corrected if he had made it clear that he had filed the complaint, if he had made that clear to us. However, we would still argue that it would have to be a correction done within a prompt amount of time, as that's a standard enumerated within Rule 11.01, Your Honor.
And the correction you're talking about is just simply the filing of a notice of entry on the case?
He could have filed a notice of entry and made it clear to the court that he was the individual who had signed the complaint. However, in this particular case, there was such a delay of 146 days that it did not constitute a prompt attempt to correct the significant deficiency with the initial complaint.
I don't have anything further.
Okay, thank
All
you.
right, we'll hear from you, Mr. Rickman. Mr. Rickman, you're muted. You're muted.
I'm sorry about that, Your Honor. Yes, initially, I would like to note, as far as the motion to exclude the appendix, what that motion was to exclude that particular piece of paper, that printout from the court's website. It doesn't affect the fact that that's still a matter of public record. It's still something anyone in the state or anywhere with internet access can obtain as information as to who the filing attorney in this case was. So that is still something the court can take judicial notice of if the court excludes that particular appendix. And I think that's an important fact. Also, I want to take issue with what James River has said, that the issue that, in fact, Mr. Severes was the filing attorney, according to the clerk, wasn't brought up in the proceedings, because it was. At page 8 of the argument, it was clearly pointed out to the court that he had been listed with the court clerk as the filing attorney since the inception of the case. So that fact was borne out to the trial court in this hearing, that since the inception, he was the attorney listed, not me. He was the attorney listed as the filing attorney with the court clerk in this case. And as far as James Rivers' argument about more deference to pro se litigants in these cases that they have cited, this is an apples and oranges argument. It doesn't apply. None of these cases dealt with how the complaint was filed. They all dealt with who filed the complaint. And I don't believe they're taking issue, and certainly there's no evidence to refute the fact that Mr. Severes did file the complaint in this case.
Let me ask you a question, Mr. Rickman.
Yes.
What is the legal effect of an attorney failing to comply with Rule 11, i.e., let's assume for the moment that you've got a signature on the complaint, albeit it's Mr. Severes' signature, but he doesn't have all the information that's on there. What's the legal effect of that?
Well, Your Honor, I'll tell the court this. There's to my knowledge, and I'm assuming,
Mr. Rickman.
I'm sorry.
What does the law say?
There's no case law on this point, Your Honor. None that I've found. I'm assuming none that James Rivers found. They've cited none. There's never been a case dismissed because the filing attorney didn't include their bar number on the complaint.
Is that the only thing that's lacking here?
Well, his personal information is also lacking. That was subsequently provided by the affidavit, and the bar number as well provided by the affidavit.
Opposing counsel suggests that because she didn't actually say it this way, but I think she suggested the fact that because the complaint was not signed accurately, there may be some prejudice in the collection of court costs or being responsible for such things as that. What's your position?
I think the affidavit corrects that, Your Honor. Any possible prejudice that was there. And again, there's really no prejudice in this case. There'd been no prejudice in allowing Mr. Smith to amend his complaint, other than the fact that James River may have to provide contractual benefits that Mr. Smith paid for. There's really no prejudice that this case would turn on other than that. And again, as far as the delay, according to the trial court, the filing of the complaint was void upon filing. The statute had run by the time this issue was raised, and therefore any motion to amend was futile. And
doesn't the rule give you the benefit of? In other words, I don't know that would necessarily be the case. First of all, counsel doesn't take that position, at least at oral argument. But in other words, the rule seems to say if you do it promptly, you can get it corrected. Is it your position that this was done within the promptness requirement of the rule?
Well, Your Honor, it was an unusual situation.
Attempted to be done.
It was an unusual situation. There's only, as I saw it, there had been two ways to fix this. It is with an amended complaint, that it has to be done by consent or by leave of court. We thought that once this matter was cleared up and an affidavit was provided to opposing counsel before this response was filed, and frankly, we thought that might resolve the issue. It didn't. And therefore we had to go the route we did. Again, there were reasons that I was away from the office for weeks at a time during this period. The court really didn't address whether or not that was reasonable or not. But
Let me
the
ask you one
fact
other
remains-
thing. I noticed that counsel alluded to this, and I remember seeing this, I think, in the brief, that not only did they file an answer and motion to dismiss, but they sent you an email indicating that this was the case. Was that in the record?
I think the email may have been attached to counsel's pleadings, Your Honor.
All right.
Let me ask, Mr. Rickman, this complaint was electronically filed. Is that right?
Yes, Your Honor.
How does who signed your name to the last page of the complaint?
Mr. Severe's.
And that was done electronically.
Well, I believe it's an actual signature. It's not an electronic signature. It's an actual signature.
Okay.
Then
All right.
converted to PDF format and filed with court.
Okay, I got you.
Under his account, him listed as filing attorney, as counsel for plaintiff in the case.
Okay.
Okay, counsel, we appreciate your argument. We will attempt to get you an opinion at the earliest possible date. You have given us some things to consider and mull over. And again, we appreciate it. And Mr. Hibner, with nothing further, that concludes this case, and we'll be in recess to the call of the next case.